Hello, good day, everyone. Our group is about to report Rule 131 of the Rules of Court, the burden of proof, burden of evidence, and presumptions. Together with me are my group mates, Mr. Renan Mendoza, Ms. Charmy Joyce Maningo, Miss Lakeisha Lalas, Miss Jessabeth Magdayao, and yours truly, Miss Ellen May Reuyan. Our first reporter is Miss Jessabeth Magdayao. Take it away, Ma'am Beth.
Good day, everyone. So here's a report on burden of proof, burden of evidence, and presumptions under Rule 131 of the Rules of Court. The contents of our report are the following. First, in Section 1, we have burden of proof and burden of evidence. Section 2 on conclusive presumptions. Section 3, we have disputable presumptions. Section 4, we have no presumption of legitimacy or illegitimacy. Section 5 on presumptions in civil actions and proceedings. And lastly, in Section 6, we have presumptions against an accused in a criminal case. Now let's proceed to section 1 of Rule 131 that talks about burden of proof and burden of evidence. So what is burden of proof? As defined in section 1 of Rule 131 of the Rules of Court, burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shifts. So basically, this burden of proof as a general rule lies with the party who alleges the existence of a fact or a thing necessary in the prosecution or defense of an action. So he who alleges has the burden of proving it. Now, what is burden of evidence? Burden of evidence, as defined in section 1, is the duty of a party to present evidence sufficient to establish or rebut a fact and issue, establish a prima facie case. Burden of evidence may shift from one party to the other in the course of the proceedings, depending on the evidences of the case. So, if the accused admits the killing, then the burden of evidence is shifted to the accused to prove his or her defenses. Now, let's talk about the distinctions between burden of proof and burden of evidence. So, as to the duty of the party, it is in burden of proof, it is the duty of a party to present evidence to establish his or her claim or defense by the amount of evidence required by law. So, in civil cases, it is a basic rule that the party making allegations has the burden of proving them by the preponderance of evidence. In administrative cases, the complainant bears the burden in proving the averments of his complaint by substantial evidence. And in criminal cases, the prosecution bears the burden of proving that the accused is guilty beyond reasonable doubt. In burden of evidence, it is the duty of the party to go forward with the evidence to overthrow the prima facie evidence against him. And then, as to burden of proof, and the burden of proof as provided in Section 1, Rule 131 of the Rules of Court, it never shifts. While burden of evidence, it may shift from one party to the other in the course of the proceedings depending on the exigencies of the case. So this is also based in Section 1 of Rule 131 of the Rules of Court. Now, as to the determining factor in burden of proof, it is generally determined by the pleadings filed by the party, while in burden of evidence, it is generally determined by the developments of the trial or by the provisions of substantive law or procedural rules which may relieve the party from presenting evidence on the facts alleged. Now, upon whom the burden of proof rests. In civil cases, the burden of proof is on the party who alleges a fact and who would be defeated if no evidence is given on either side. Such party must establish his case by a preponderance of evidence, which means that the evidence as a whole adduced by one side is superior to that of the other. So that is in the case of De La Cruz versus Octaviano, GR number 219649 on July 26, 2017. And in criminal cases, the burden of proof to establish the guilt of the accused falls upon the prosecution, which has the duty to prove all the essential ingredients of the crime. So that is in the case of Sierra versus Court of Appeals. Now, what is equipoise doctrine? The equipoise rule or equiponderance doctrine refers to a situation where the evidence of the parties is evenly balanced or where there is doubt on which side the evidence preponderates or weighs more heavily. In this case, the decision should be against the party with the burden of proof. So that is found in Riano Evidence in the Bar Lecture Series 2002 edition, page 60. Now we have here a case of Prieto versus Kajimat, GR number 214898 on June 8, 2020. Facts of the case: petitioner Randall Jr. was driving a red Yamaha tricycle over two tricycles in front of him, which resulted in the instantaneous death of the Jimat. A criminal case for reckless imprudence resulting in homicide was filed against petitioner Randall Jr. before the MCPC. The mother of the deceased, respondent Erlinda, posited that at the time of the incident, petitioner Randall Jr. did not have a driver's license and was intoxicated. She pointed out that the direct, immediate, and proximate cause of the collision was petitioner Randall Jr.'s gross negligence in managing, driving, and operating the red Yamaha tricycle. The MTPC required or rendered a decision finding petitioner Randall Jr. guilty beyond reasonable doubt of reckless imprudence resulting in homicide, which fact was admitted by both parties. The RTC, applying the principle of res et salutator, rendered a decision finding petitioners Randall Jr. and Prieto negligent and are therefore civilly liable. In addition, the RTC reasoned that insists that Jimat III cannot be considered contributory negligent in the vehicular mishap as there was no evidentiary proof that his motorcycle did not have a headlight at the time of the collision. The CA rendered its decision affirming in total the RTC's decision. Issue where the petitioner is able to prove the truth of their claim or defenses. So the ruling here is that no, the party who alleges a fact has the burden of proving it. Section 1, Rule 131 of the Rules of Court provides that the burden of proof is the duty of a party to prove the truth of his or her claim or defense or any fact in issue by the amount of evidence required by law. In this case, the burden of proof rests upon the petitioners who are required to establish their case by a preponderance of evidence. However, aside from petitioners' allegations, no other evidence was presented to prove that indeed the deceased was negligent in driving his motorcycle. So that's the end of my report. Thank you very much for listening, and the other parts will be discussed by my co-reporters. Once again, good day, everyone. So here's
The next reporter will be Miss Lakeisha Lalas.
Good day, attorney, and good day, classmates. Today I'll be reporting on conclusive presumptions under Rule 131 of the Revised Rules on Evidence. Let's first define a conclusive presumption. A conclusive presumption, according to Reuyan, is a presumption which is irrebuttable and any evidence tending to rebut the presumption is not admissible. So, Section 2 of Rule 131 of the Revised Rules of Evidence provides that the following are instances of conclusive presumptions. A. Whenever a party has, by his or her own declaration, act, or omission, intentionally and deliberately led another to believe a particular
Wait
thing
lang yan.
true and to act upon such belief, he or she can. Good day, attorney, and good day, classmates. Today I'll be reporting on conclusive presumptions under Rule 131 of the Revised Rules on Evidence. Let's first define a conclusive presumption. A conclusive presumption, according to Reuyan, is a presumption which is irrebuttable and any evidence tending to rebut the presumption is not admissible. So, Section 2 of Rule 131 of the Revised Rules of Evidence provides that the following are instances of conclusive presumptions. A. Whenever a party has, by his or her own declaration, act, or omission, intentionally and deliberately led another to believe a particular thing true and to act upon such belief, he or she cannot, in any litigation arising out of such declaration, act, or omission, be permitted to falsify it. And B. The tenant is not permitted to deny the title of his or her landlord at the time of the commencement of the relation of landlord and tenant between them. The following are instances of conclusive presumptions under the rules and the law. First, we have estopel in pay, and second, we have estopel against the tenant. Estopel in pay basically just means estopel out of court or without legal proceedings. And for the second kind of estopel, we will discuss that in the succeeding slides. The case of Midway Maritime and Technological Foundation versus Castro clarified that what a tenant is stopped from denying is the title of his landlord at the time of commencement of the landlord-tenant relation. In this case, the Supreme Court held that it is settled that once a contract of lease is shown to exist between the parties, the lessee cannot by any proof, however strong, overturn the conclusive presumption that the lessor has a valid title to or a better right of possession to the subject premises than the lessee. Section 2B of Rule 131 of the Rules of Court prohibits a tenant from denying the title of his landlord at the time of the commencement of the relation of landlord and tenant between them. So, if the title asserted is one that is alleged to have been acquired subsequent to the commencement of that relation, the presumption will not apply. The case of Santos versus NSO is also instructive. Here, the Supreme Court held that the rule on estoppel against tenants is subject to a qualification. It does not apply if first, the landlord's title has expired, second, it has been conveyed to another, or third, it has been defeated by a title paramount subsequent to the commencement of lessor-lessee relationship. In other words, if there was a change in the nature of the title of the landlord during the subsistence of the lease, then the presumption does not apply. The law provides for other presumptions, such as conclusiveness of judgment and knowledge of the law. For conclusiveness of judgment, the judgment or order of the court is deemed conclusive when so declared by the court to be conclusive. And for knowledge of the law, this is presumed, and its ignorance is not a defense for its violation. Here we have other rules on presumption under the rules of court and Philippine law. So, in case of judgment or final orders by a Philippine court, the effect of a judgment or final order rendered by a court of the Philippines is conclusive upon the title to the thing or conclusive between the parties and their successors in interest, as the case may be. So the judgment or final order is conclusive upon the title to the thing in case of a judgment or final order against a specific thing, or in respect to the probate of a will, or the administration of the estate, or in respect to the personal, political, or legal condition or status of a particular person or his relationship to another. On the other hand, the judgment or final order is conclusive between the parties and their successors in interest by title subsequent to the commencement of the action or special proceeding, litigating for the same thing and under the same title and in the same capacity. This is provided for under Section 47 of Rule 49 of the Rules of Court. Then we also have the rule on presumption in case of foreign judgment or final orders. Section 48, Rule 39 of the Rules of Court provides that in case of a judgment or final order upon a specific thing, the judgment or final order is conclusive upon the title to the thing. Then, in case of judicial confession, the presumption is that no sane person would deliberately confess to the commission of a crime unless prompted to do so by truth and conscience. This is why it constitutes evidence of a high order, and admission of guilt constitutes evidence against the accused pursuant to Rule 29 and Rule 30 of the Rules of Court as stated in the case of People versus Baskukin. Now, in case of forgery, as a rule, it cannot be presumed and must be proven by clear, positive, and convincing evidence, and the burden of proof lies on the party alleging forgery. And finally, in case of conjugal property, the presumption that the property is conjugal property may be rebutted only by strong, clear, categorical, and convincing evidence. That ends my report on conclusive presumptions. Thank you so much for listening, and God bless.
Okay, good evening, good morning, or good afternoon, everyone, classmates and attorney. We will continue the report on Rule 131, the burden of proof, burden of evidence, and presumptions, specifically the Section 3 of Rule 131. So, as a recap, there are two kinds of presumption. We have conclusive presumption and disputable presumption. The conclusive presumption, as explained by our colleague, Ms. Lakeisha, it is when the presumption becomes irrebuttable upon the presentation of evidence and any evidence tending to rebut the presumption is not admissible. However, in a disputable presumption, species of evidence that may be accepted and acted on when there is no other evidence to uphold the contention for which it stands, or one which may be overcome by other evidence. So, Section 3 of Rule 131 enumerates those disputable presumptions. As you can see in the slide, letter A, that a person is innocent of crime or wrong. Letter B, that an unlawful act was done with an unlawful intent. Letter C, that a person intends the ordinary consequences of his or her voluntary act. Letter D, that a person takes ordinary care of his or her concerns. Letter E, that evidence willfully suppressed would be adverse if produced. Letter F, that money paid by one to another was due to the latter. Letter G, that a thing delivered by one to another belonged to the latter. Letter H, that an obligation delivered up to the debtor has been paid. Letter I, that prior rents or installments had been paid when a receipt for the latter once is produced. Letter J, that a person found in possession of a thing taken in the doing of a recent wrongful act is the taker and the doer of the whole act. Otherwise, that things which a person possesses or exercises acts of ownership over are owned by him or her. Letter K, that a person in possession of an order on himself or herself for the payment of the money or the delivery of anything has paid the money or delivered the things accordingly. Letter L, that a person acting in a public office was regularly appointed or elected to it. Letter M, that official duty has been regularly performed. So in this letter M, my partner, Miss Reuyan, will give a sample case about this item. Letter N, that a court or judge acting as such, whether in the Philippines or elsewhere, was acting in the lawful exercise of jurisdiction. Letter O, that all the matters within an issue raised in a case were laid before the court and passed upon by it, and in like manner, that all matters within the issue raised in a dispute submitted for an arbitration were laid before the arbitrators and passed upon by them. Letter P, that private transactions have been fair and regular. Letter Q, that the ordinary course of business has been followed. Letter R, that there was a sufficient consideration for a contract. Letter S, that a negotiable instrument was given or endorsed for a sufficient consideration. Letter T, that an endorsement of a negotiable instrument was made before the instrument was overdue and at the place where the instrument is dated. Letter U, that a writing is truly dated. Letter V, the letter duly directed and mailed was received in the regular course of the mail. Letter W, that after an absence of 7 years, it being unknown whether or not the absentee still lives, he or she is considered dead for all purposes except for those of succession. The absentee shall not be considered dead for the purpose of opening his or her succession until after an absence of 10 years. If he or she disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his or her succession may be opened. So we also learned this one in our law on succession. The following shall be considered dead for all purposes, including the division of estate among the heirs. Number one, a person on board a vessel lost during a sea voyage or an aircraft which is missing, who has not been heard for 4 years since the loss of the vessel or aircraft. Number two, a member of the armed forces who has taken part in armed hostilities and has been missing for 4 years. Number three, a person who has been in danger of death under other circumstances and whose existence has not been known for 4 years. Like what happened in Malaysian Airlines. Diba? Number four, if a married person has been absent for 4 consecutive years, the spouse present may contract a subsequent marriage if he or she has well-founded belief that the absent spouse is already dead. In case of disappearance, where there is a danger of death in the circumstance herein above provided, an absence of only 2 years shall be sufficient for the purpose of contracting a subsequent marriage. However, in any case, before marrying again, the spouse present must institute a summary proceedings as provided in the family code and in the rules for declaration of presumptive death of the absentee without prejudice to the effect of reappearance of the absent spouse. Letter X. That acquiescence resulted from a belief that the thing acquiesced in was conformable to the law or fact. Letter Y, that things have happened according to the ordinary course of nature and ordinary nature habits of life. Letter Z, that persons acting as co-partners have entered into a contract of co-partnership. Next, additional disputable presumptions. We have letter AA, that a man and a woman deporting themselves as husband and wife have entered into a lawful contract of marriage. Letter BB, that property acquired by a man and a woman who are capacitated to marry each other and who live exclusively with each other as husband and wife without the benefit of marriage or under void marriage has been obtained by their efforts, work, or industry. Letter CC, that in cases of cohabitation by a man and a woman who are not capacitated to marry each other and who have acquired properly through their actual joint contribution of money, property, or industry, such contributions and their corresponding shares, including joint deposits of money and evidences of credit, are equal. So, to continue, Miss Ellen Mary Uyan will proceed with the other enumerated disputable presumptions under Section 3 of Rule 131.
Hello, good day, everyone. Good day, sir. Good day, classmates. So, to continue the enumeration stated by Ms. Charmaine Joyce Maningo, as part of the disputable presumptions, the following that I'm going to discuss are also part of Section 3 under Rule 131 of the Rules of Court, which are the following presumptions are satisfactorily if uncontradicted, but may be contradicted and overcome by other evidence. So under DD, that if the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, this rule shall govern in the absence of proof to the contrary. Part of the 2019 amendments in Section 3, disputable presumptions, are the words or numbers which are highlighted or in red font in this slides. So, number one, a child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. And second, a child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during the such marriage, even though it be born within the 300 days after the termination of the former marriage. So in EE, that a thing once proved to exist continues as long as is usual with things of nature. FF, that the law has been obeyed. GG, that a printed or published book purporting to be printed or published by public authority was so printed or published. Under HH, that a printed or published book purporting contain reports of cases and judge in the tribunals of the country where the book is published contains correct reports of such cases. II, that a trustee or other person whose duty it was to convey real property to a particular person has actually conveyed it to him or her when such presumption is necessary to perfect the title of such person or his or her successor in interest. Under JJ, that except for purposes of succession, when two persons perish in the same calamity, such as wreck, battle, or conflagration, and it is not shown who died first, and there are no particular circumstances from which it can be inferred, the survivorship is determined from the probabilities resulting from the strength and the age of the sexes according to the following rules. Number one, if both were under the age of 15 years, the older is deemed to have survived. Second, if both were above the age of 60, the younger is deemed to have survived. Third, if one is under 15 and the other is above 60, the former is deemed to have survived. Fourth, if both be over 15 and under 60 and the sex be different, the male is deemed to have survived. If the sex be the same, the older. And last, if one be under 15 or over 60 and the other between those ages, the latter is deemed to have survived. The last enumeration, KK, that if there is doubt as between two or more persons who are called to succeed each other as to which of them died first, whoever alleges the death of the one prior to the other shall prove the same. So whoever alleges will have the burden of proof. So in the absence of proof, they shall be considered to have died at the same time. Here, the effect of disputable presumption, as in the case of Diaz versus People, GR number 2018-113, December 2, 2013. What is the effect? The effect of presumption upon the burden of proof is to create the need of presenting evidence to overcome the prima facie case created by the presumption. So if no contrary proof is offered, the presumption will prevail. Also, in Section 3M, Rule 131, when regards to disputable presumption under the rules, so that the official duty has been regularly performed, it states that to begin with the presumption of regularity in the performance of official duties should should not even be relied upon because there was concrete and undeniable evidence of lapses committed by the arresting officers in their compliance with the affirmative safeguards. In the case of Casona versus People, JR number 179757, September 13, 2017, states that it would be unconstitutional to place a higher value in the presumption of regularity in the performance of official duties as mere tool of evidence. That in the more substantial presumption of innocence favoring the petitioner as an accused, a right enshrined no less than in the Bill of Rights. Another disputable presumption under the rules when it comes to the official duty has been regularly performed. The People versus Casabuena, November 19, 2014 states that the presumption of regularity in the performance of official function is applicable only when there is no deviation from the regular performance of duty. Also in People versus Alejandro, April 7, 2014, it is a reputable by affirmative evidence of irregularity or of failure to perform a duty. So in the last case, as to disputable presumption based on jurisprudence, in the case of Maliwat versus CA 256-718, provides that in the absence of satisfactory explanation, one found in possession of and use a forged document is the forger and therefore guilty of falsification. If a person had in his possession a falsified document and made use of it, taking advantage of it, profiting from it, the clear presumption is that he is the material author of the falsification. So the next report will be continued by my teammate, Mr. Renan Mendoza.
Hello ma'am siya na nag-run out sa mga bago na ibalik.
Sige. Ikaw na, sir. It's your,
Grabe naman yung struggle.
it's your time to shine. We're recorded pala.
Umana kalin, i-continue na nako.
Yes. We are recording na.
Go na. Go na. Ah, good evening, good day, sir, ma'am. Sinsya na kay naputol na pud kay nawala nag-run out. So, my report is all about section 4, 5 and 6 of the rule 131 of the rules of court. So, under section 4, it was being provided that no presumption of legitimacy or illegitimacy. There is no presumption of legitimacy or legitimacy of a child born after 300 days following the dissolution of the marriage, of the separations of the spouses. Whoever challenges the legitimacy or illegitimacy of such child must prove his or her allegations. So now, before we will going to tackle with regard to section 4, let us first examine what are the legitimate presumptions as provided in the uh, family code. So under the family code, any child born outside of during the existence of a valid marriage is considered as a legitimate child. Child who was born outside of a valid marriage is considered as illegitimate child. So another presumption by the law that whenever a spouse contracted a subsequent marriage, child who is
Oh,
born
naman.
within 180
Na-move na
days
na ko na.
from the dissolutions of the marriage is considered as legitimate child of the first marriage. Now, whenever a child is born more than 180 days, it is considered as legitimate child of the subsequent marriage. Now, let's go with the particular provisions of Section 4 as it provides that whenever a child is born more than after 300 days following the dissolutions of marriage, the presumption of legitimacy and legitimacy cannot be presumed. So, in that case, so we will going to cross-reference with the family code on how we will going to establish the legitimacy and illegitimacy of the child. So, uh, on the impunity of the legitimacy of the child as provided in the Article 166 of the Family Code, it provides that the legitimacy of the child could be impugned um, by the following circumstances. First is the physical incapacity of the husband. Um, physical incapacity uh, physical incapacity by reasons of a whenever a husband and wife has a long distance relationship and the child was being born thereafter, then it is impossible for um, it is impossible that the child is a legitimate son of that putative father. So there is a physical incapacity. Second, physical impossibility by reasons of illness. So whenever the husband or the wife has a illness as to reproductions and then the child has been conceived. So there is a question with regard to legitimacy. Another one, how to prove legitimacy how to impugn legitimacy. So by the use of a biological or other scientific reasons, the child could not have been that of the husband. So by using of scientific method by way of DNA examination. So whenever a putative father or putative father question the legitimacy of the child, so he can use a scientific method by way of presenting the DNA that he is not really the father. So that it's one way of proving legitimacy. Another one, uh, how to prove legitimacy. So, legitimacy or legitimate filiation can be proved by means of the record of birth certificate appearing in civil registrar by a final judgment and admission of legitimate affiliations in the public documents or private handwritten. The absence of foregoing evidence, the legitimate filiation shall be proved by the open and continuous position, the status of legitimate child, or any other means allowed by the rules of court. So, as provided by these rules, the the way of proving legitimate filiation is also the way of proving illegitimate filiations. However, in the uh, illegitimate filiations, there are certain provisions that does not goes does not correspond with the legitimate filiation. So we have also here when and who may file the legitimacy or illegitimacy. So when the action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to heirs should the child be during minority or in a state of insanity. In these cases, the heir shall have a period of 5 years within which to institute the action. So this particular provisions is applies only with regard to legitimate filiations. So with regard to illegitimate filiations can only be proved during the lifetime of a putative parent. So meaning whenever the putative parents already died, so you are being barred to file to prove your illegitimacy or illegitimacy. Now, let's go with the section 5 of section 5 of Rule 131, presumption of civil proceedings in civil presumption civil actions. In civil actions and proceedings not otherwise provided for by the law, the rules of presumption imposes on the party whom it is directed to burden and going forwarded with the evidence. Now, we have here an example. Sa example, on the nature, it is nature of sale. So the civil action that could be filed on sale is the nullity of sale. So the presumption of the law on the sale that it is executed regularly. So meaning the consent of the party, all the elements of the sale was being present on the transaction, consent, cause, and consideration. Another one, whenever evidence such as date of sale was being presented, the presumption of the law that the date of sale was executed regularly. So therefore, the effect of that is that the burden of proof lies on the person to question the legitimacy of the sale. So meaning if you who is the one who filed a nullity of sale has the burden of proof to prove that there is an irregularity during the execution of the sale. So that was main on in these particular provisions. Another example is on transportations. So the civil action that could be filed is arising from a quasi delect. So the presumption of the law with regard to a common carrier that whenever there is an accident or there is an towards incident that will be happening, it is always that the common carrier is neglected. So how could the burden of proof. So the burden of proof lies on the common carrier itself to prove that they did not acted in negligence at all. So how he can prove that he did not acted negligence? So he must show that he acted an extraordinary diligence uh, in supervising or in hiring his worker. So the last provision will be the Section 6. So Section 6, presumptions against an accused in criminal cases is if presumed for the establishment of guilt, it is an element of the offense, charge, or neglect defense. The existence of basic facts must be proved beyond reasonable doubt, and presumed fact follows from the basic fact beyond the reasonable doubt. So example here is on a crime of BP 22. So on BP 22, the presumption of law that the person issued a check knows that uh, his bank does not have insufficiency of fund. There is insufficiency of fund on his bank. So that is a presumption of law. Now the burden of proof is that the uh, the burden of evidence lies on the prosecution to prove beyond reasonable doubt that the person who issued the check who violated the BP 22 has uh, uh, has the knowledge from the very beginning that his bank account is insufficient of funds. So that is a presumption. Next, we have also an example. Uh, Next slide, ma'am. So we have example here, estapa through misappropriation under Article 315. So the presumption of law here is that whenever you did did not return the property, return the money or any fund at all, so there is a misappropriation. So meaning if the presumption of law that whenever you hold that particular property into a misappropriation, you use that in your personal use. So the burden of evidence lies on the prosecution to prove beyond reasonable doubt that the person who committed estrapa to misappropriation of fund um, has used that personal property for his personal use. So another example that it could cite is an example of the crime of theft. So the presumption of law on the crime of theft that the person who committed the theft as one of the essential element is the intent of gain. So the burden of evidence lies on the prosecution to prove the burden of proof beyond reasonable doubt that the person take the property with an intention to gain. So that's all about our report. Thank you and God bless.
So that ends our report, classmates, about Rule 131 of the Rules of Court, the burden of proof, burden of evidence, and presumptions. Thank you so much for listening and have a happy, healthy mental health break. Thank you.
Thank you. Bye.